today is about breach of contract and its consequences. Yeah, and of course, after that, we will also discuss about the defenses. Yeah, or how the claim when it is filed by one party against the other party, how the other party that is claimed can defend themselves. Yeah, so it's a defense. Yeah, it's a defense. um, how to defend yourself, yeah, something like that. Yeah, when the claim comes, so it will be discussed next week. It will be shorter than this one, because this one I think is quite a lot. Yeah, the subject that I will give today, well, maybe it's not very much, but the debates, yeah, the arguments, the different arguments sometimes, yeah, between the parties in a contract like this are so many. Yeah, so let's see. Yeah, we can learn today. And also, if you look into the practical cases, yeah, the case studies in the courts, so many interesting dispute, yeah, that is not easy sometimes to understand. Yeah, because breach of contract has many dimensions actually. So let's see the basic things. In here we see from subjecti, yeah, that there are 4 types of breach of contract. The debtor does not fulfill its obligation at all. Yeah, so he doesn't do anything, or he doesn't do what he has promised to do. Yeah, that's, I think, the easiest. Yeah, the easiest and the simplest form of breaching your obligation. And then the second is the debtor is late in fulfilling its obligation. You promise to do it on the 10th of the month, yeah, the 10th day of the month, but you do it on the 12th day of the month, for example. Yeah, that is also already considered as a breach of contract. Yeah, because it is like obligation with time period. Yeah, if you remember, we have a concept of perikatan dengan ketetapan waktu, ya, obligation with a definite period of time or definite time period. So if it is agreed already that a certain time, at a certain time and a certain date, you have to do something or you have to deliver something, but you don't do it, then it will be considered as a breach. Yeah, the debtor incorrectly or inappropriately fulfills its obligation. Okay, so you fulfill your obligation. Yeah? At least, now this is the debate comes in. Yeah, this is where the debate comes in, because you said that you fulfill your obligation. Yeah, I have done my part, but actually you have not. Yeah, because there are some defects perhaps, yeah, in your performance, or you have to do 10 items when you deliver something, but you only do 7 items, for example. Yeah, well, the product or the service might be delivered, yeah, but the way how you deliver it is violating the contract. Yeah, so that's why the debtor incorrectly or inappropriately fulfills its obligation. This one is not easy, this aspect. Yeah, if you are going with the A, the debtor does not fulfill its obligation at all, well, it's very simple, right? When you have to do this, you don't do it, you are breaching the contract. Yeah, and B is also quite simple. When you are doing this, when you should be doing it on the 10th day of the month, but you have done it only on the 12th day on the month, well, it's breaching the contract, right? Not much debate, not much arguments on that. But on C, sometimes there will be a debate, because the debtor will defend their position, and also the creditor will consider that there are some violations, conducted by the debtor, or the debtor performing something that is prohibited under the contract. So the D in here is relevant to the performance, prestasi, If we look into performance or obligation or prestasi, there are three types, right? To deliver something, to do something, or not to do something, In a contract drafting, I don't know whether there is any subject on contract drafting in your. If you learn how to draft a contract properly, you will learn about covenants, Then there will be affirmative covenants, and then there will be negative covenants. Affirmative covenants, which means that you promise to do this, that, You to do A, B, C, D, E. You promise to do something. That's affirmative covenants, That you will do this, you will do that during the period of the agreement. But the D in here is actually a negative covenants, Because you promise not to do something, So if you promise not to do something, or because it is prohibited under the contract, because prohibition means you cannot do anything, right? You are prohibited to do something, so you suppose not to do something. So if you do it, there will be a violation of the contract. So in the contract, it will be called as negative covenants. So you promise not to do this, that, negative covenants. For example, like when you obtain financing loan from the bank, for example, there will be negative covenants like you cannot obtain any more debts, You are not allowed to obtain additional debt unless it is agreed in writing by the bank, for example, right? So you are not allowed to obtain a new debt. That's negative covenants. I will not change the structure of the management of the company until the debt is fully paid. Or as long as the debt is still there, I promise not to change the structure, the directors, the members, the composition of BOD, and also the shareholders of the company, for example. So you will see that in the financing agreement or in the loan agreement, the basic thing is about lending money, right? So the bank gives money and you have to repay, right? That's the basic thing of the loan transaction. But if there is a negative covenant, or there is, or maybe there are some violations of negative covenants, you do what you supposed not to do, well, it is considered as a breach of contract. And since it is considered as a breach of contract, the loan agreement can be considered as due and payable by the bank. So do you follow what I meant? I hope you follow what I mean. Because the bank gives the money as a loan, right? This is a loan transaction actually, and what you supposed to do, the essential things that you have to do is to repay the money, right? Repay the money with the interest. Let's say that you do that, you do repaying the money with an interest, but you violate the negative covenants in the agreement. It's something else. The negative covenants, perhaps you are restricted to change the structure, but you do it anyway. You are restricted to change the articles of association, but you do it anyway. You are restricted to get additional loan, but you do it anyway. So there are breaches of contract because you violate the negative covenants in the loan agreement. Yeah, you keep on repaying the money, right, with an interest. But since you are violating the negative covenants, the bank may consider that the loan will be due and payable, because the loan will have time period, right? Let's say it's 3 years, 4 years, 5 years. Yeah. But if you are violating the contract on the second year, the bank can consider it is due and payable on the second year, not on the third, fourth, fifth, as what is agreed. So the A, B, C, D in here, these are the 4 types of breach of contract. Yeah. So it is quite wide actually. Yeah, it is. It can be many things. It can be many examples. Yeah, the A, B is late. This is relevant for sell and purchase, for example. Lease agreement, for example. Loan agreement is always relevant with the time, right? There will be time period to do this, to do that, yeah, to deliver, to give back the space and the rest. Okay, so and then penalty, yeah. Okay, let's say this is as consequences, yeah, consequences of a breach of contract. There are 4 types of consequences, yeah, for negligent debtors or defaulted debtors, yeah, defaulted. Paying losses, of course, right? So this is the most common, yeah. If you are doing something in violation of the agreement, you might have to pay compensation. Paying losses suffered by the creditor, yeah, because when you violate the agreement, there will be losses by the creditor. So you have to compensate it, yeah. So it's, yeah, well, this is a justice and fairness principle, yeah, because contract is binding, right? When it is binding, you know from the beginning, when you enter a contract, yeah, you know that you will have to do what is agreed in the contract, yeah. The agreement will cover the rights and obligations, right? You have to do what is obligated under the agreement. And if you don't do it, yeah, if you don't do what has been promised in an agreement, of course there will be other party that's suffering, right? There is suffering. When the suffering is entering the picture, of course the balance will not, or let's say the scale will not be balanced anymore, yeah, because one party is suffering, one party is, let's say, like gaining something out of the suffering of the party. So based on the fairness principle or justice principle, you can say that of course there should be compensation, yeah, to return the scale, to make it balance again, yeah, so that the creditor and debtor is with this position, yeah, so with this scale, yeah, so you are in balance, not out of balance, yeah, because if you are out of balance, the law should find a way to make it balance again, right? That's the fairness and the justice principle in an agreement law. And that's why if you are breaching a contract, you have to pay losses. Well, it's not everything, yeah. The second thing is cancellation of the agreement. We will look under Article 1266 and 1267, yeah, that there is a time when the agreement will be cancelled, yeah, or requested to be cancelled also, other than requesting only to pay losses, yeah. Well, I think most of the time, if you are violating an agreement, the claim will be for breach of contract and also for cancellation. I think most of the time that you will see. But it's not compulsory like that, yeah? You actually can choose whether you want to just focus on the compensation, but let the agreement be valid between the parties so you don't terminate the agreement, or even you focus on the performance only, yeah? So the losses equals to performance, yeah? You have to do it anyway, even though you are breaching the contract, or you focus on all things, yeah? You cancel the agreement, you request for paying compensation losses. And the third one is risk assignment, yeah? We will look into it later on, because there will be risk assignment if there is a breach of contract, but this is not happening in every cases, yeah? I think from Pak Subekti, from Professor Subekti, I think it's only related to sale and purchase actually. And pay the court fees, yeah, if the case is submitted before the judge. Well, yes, the court fees will have to be paid if you become the loser, yeah, if you are the loser party, yeah. So it's not all the time that you have to pay. I mean, you as the party violating the agreement, you have to pay. Yes, as long as you are the loser, yeah, you are the defeated party. But in sometimes, in few times, yeah, not all the time, the party breaching the contract can file defense, right? When there is a claim against them, they can do some defense, and then the court will say that there was no breach of contract. So if there was no breach of contract, perhaps due to the force majeure, perhaps, yeah, act of God, or maybe because of the claimant was doing the first breach of contract, so the claimant did it the first time. That's why, because of the claimant's default, the defendant becomes defaulted. Yeah, that can be also lodged. So it's not all the time that the parties as defendant, ya kan ada penggugat ada tergugat, right? Claimant and defendant. That the defendant will lose, right? No, it's not like that. So when we refer to the fourth element in here, pay court fees, yes, it is, as long as the defendant is the losing parties. If it is won, if it is the winning party, it doesn't need to pay the court fees. Yeah, the court fees will be paid by the loser. So if the claimant is the losing party, the claimant will have to pay the fees. Well, anyway, it's not much. Yeah, it's very minor, so no need to bother. Okay, what else? Breach of contract has such important consequences, so it must be determined in advance whether the debtor is default, and if it is denied by him, it must be proven in front of the judge. Yeah, well, this is what is happening all the time in the transaction, actually. Yeah, one party will declare that you are defaulting. Yeah, sometimes the other party admits, yes, I was wrong, I'm sorry. Yeah, but sometimes they will deny. Yeah, they will decline. No, it was not true. You know, I have done this, I have done that. Yeah. Well, if it is admitted, yeah, if it is admitted by the other party, I think it's very simple, right? Now what? You are breaching the contract. You are saying you are sorry. Do you still want to rectify your actions or not? Yeah. If you want to rectify, and you are what is that? Yeah, you are able to do it, then of course I think a settlement is appropriate. A settlement to proceed I mean, like, no need to go to the court to have this dispute, right? If it is settled, then we can proceed. Sometimes it is not like that, right? So there was an argument, there was a debate. So one party has to choose, yeah, which party, yeah, whether the A or B will have to file a claim through court. Sometimes, yeah. Or maybe if A is satisfied to just terminate and forget about everything, that's also fine without the court's involvement. Yeah. So of course, it's not necessary to involve the court all the time, yeah, because we don't have the time for that, right? We don't want to have a business, but every dispute, every conflict, we will resolve it through court. It will take a lot of times, and we don't really want to do it, because in business, what is required and what is important for us is to do business, right? We don't want to spend so much time in dispute, because in dispute, I've experienced many disputes already, representing client in disputes. When they face legal disputes, many divisions will be involved, yeah, because some documents are with this division, some documents are with that division, some documents with this. So of course they have to be involved in order to prepare the defense, right, or the claim itself, yeah. So many divisions, not only legal divisions, yeah. And also, anyway, legal division will be led by some directors, yeah, maybe director of finance, CFO. CFO is normally dealing with legal issues in the company. So when the company is facing a dispute, CFO will step in, a legal division will step in also, and the other divisions that are involved, yeah. So it takes a lot of time, to prepare a defense, to prepare a claim. It's not only the time by the lawyer's team, yeah, but also by the company's team. At least what the company should do is to search the documents, right? That's the least they have to do. Let's say they don't want to be involved with the legal team, with the lawyer's team. They don't want to be involved. But at least the least that they should do is to seek for documents, right? We were involved in a labor case like 1.5 years ago, and the claim was related to the outsourcing, and the claim was saying that our outsourcing agreement was invalid, yeah, because it was not validated by the Ministry of Labor, yeah, by the instance Dinas Tenaga Kerja in the local area and everything, yeah. So it is like 15 years back, Can you imagine? I think it's around 15 years back, or maybe 20 years back, yeah. So they claim something that is 20 years back, yeah. Well, the company, the company that we were representing is not just a normal company. It's a very good company. It's a huge company. It's a public company. But I don't know why they don't really keep their records properly. So they don't really have all the documents 15, 20 years ago that the claimant were claiming, yeah. So they have to search for it, right? They have to contact the previous company that they have been involved with. There are three companies. Some they found, some they don't find it, right? But eventually they can collect many documents, but not in original version anymore. But that's okay, yeah. At least they can collect. Well, by collecting the documents itself, that's the least that the company should do. But it's not easy. It takes time. And when we dealt with the labor case, I think they did it. they needed a lot of time to do that, because they have to contact this company, that company, this company, that company, just to brief about the case, right? And then requesting for the documents. So it's not easy. Yeah, and it took time. You don't want it lah. Yeah, that's why the business transaction, of course, the business conflict, we want to settle outside the court. Yeah, I think from the business perspective, that should be the case. Yeah, but of course, as lawyer, I'm preferring more to have the case resolved in the court, yeah, than outside the court. Yeah, because I like litigation cases. I like to be involved in litigation, so that's what I like. But I also put my put my shoes on the mindset of the businessman. Yeah, the businessman doesn't like it. Yeah, unless they must do it anyway. Yeah, if they have to do it, then they will do it. But if they can find a way out of it, they will always find a way out of it. Yeah, because when you enter the litigation, yeah, you file a claim through a court. Like I said, you will spend time for it, right? You will spend energy for it. You will spend resources for it. Yeah, the number of employees that are involved will be there, right? The money that is involved, you have to pay the lawyer's fees, right? You have to pay the court fees. And if you are involved in an arbitration, it is even more, yeah, because you have to pay arbitration cost. And arbitration cost is a lot higher, a lot higher than the court. It can be like 100 times, 200 times more expensive than the court. And there is always a risk by the businessman that after they even win the case, they cannot execute the decision, right? Because it's no point. For example, even though they can execute the decision, there is no assets by the debtor. Debtor doesn't have any more assets. So it's useless to execute, yeah, because they don't have any assets. What to do then? It's useless. We win, but we cannot do any execution because the debtors doesn't have any assets. Or the debtors, when we would like to execute the decision, the debtor becomes bankrupt. So there is always a risk, right? So that's why it is better. Yeah, it is better if it is not very, very necessary. Just resolve it outside the court. Yeah. But if you imagine, yeah, if every case are resolved outside the court doesn't have any work, right? Or they will have less work than now, at least, yeah. But if they have less work, of course, less legal precedents, right? Less jurisprudences, yeah. And that is not very good, right? Because we as students, yeah, law students and prospective lawyers, we have to learn from the legal consideration of the judges, right? So we need those precedents, yeah? We need those jurisprudences, yeah, so that we can look, we can read, we can study, we can understand, and we can match the legal considerations by the judges with the what we learn in the class like this, right? So, well, it is good to resolve it out of court, but it is also good to learn from the judges, yeah? So it is also good to see it settled in court, right? So I think what is best is just a balance of it, yeah? Well, it's not all the time settled outside of the court, yeah? Because if that is the case, we cannot learn so much. Okay, sometimes it is not easy to say that the person is defaulted because often the parties do not determine when the performance must be made. Yes, this can happen. Yeah, when you do an agreement, you might forget to regulate this kind of thing. In sell and purchase, it is not determined when the goods should be delivered to the buyer's home or when the buyer must pay the price. Well, this is very confusing. In an obligation to not to do something, it is easiest to set when a person is default, because if the person does something that is prohibited, it is violated. Okay, you can say that, yeah, you can say that. If you promise not to do anything, if you are restricted to do something but you do it anyway, well, that's easy, right? I mean, it's not much of a debate, yeah, to say that you are violating the contract. If in an agreement the time due is not stipulated, such performance must first be requested or demanded. The creditor must demand that he or she demands such performance. Okay, so this is related to the previous slide, yeah, because in here, sometimes it is not determined when the goods should be delivered, right? When the payment should be paid. So if in an agreement the time due is not stipulated, maksudnya jatuhnya waktu atau kapan itu harusnya dilakukan, ya. The time due itu jatuh tempo lah, bisa dibilang. Such performance must be first requested. So what we should do then? We should send somasi. You learn about somasi, right? Somasi is LOD, letter of demand. Yeah, I demand you to do what you promised to do. So if there is no stipulations or regulations or provisions, yeah, in the contract about the timing, then you can create the timing, yeah, by giving a letter of demand. Yeah, you give them time to proceed with their obligation. If they don't proceed with their obligation, then these consequences will happen. Letter of demand, yeah. In English, I think mostly they use it as letter of demand. Bukan letter of warning, yeah. It's not the same. Yeah, they don't say it warning. Although many Indonesians use that phrase, yeah, replacing the somasi. I think the better term is demand, yeah. So they demand you to do what you have promised to do. Letter of demand. In here we call it somasi. So how many times? Well, this is a best practice, yeah. There are the Indonesian Civil Code doesn't really stipulate that it has to be twice, it has to be 3 times, right? No, there is none. But there is quite a must that you should at least send a letter of demand. I think it's a good thing to do. Yeah, it's a good thing to do to show you that you're still giving them time to complete their obligation. Yeah. Let's say that the loan should be paid on the 10th day of the month, right? They don't repay the loan. So you send a letter of demand on the 11th, for example, demanding them to repay within 3 business days, for example. So it's a good faith, right? It's a good thing to do. It's showing that you are still giving them, the debtor, time to do what they have promised to do. You don't just go to the court immediately and file a claim, or you immediately terminate the contract, for example, right? So it's a good thing, even though it doesn't mean that if you don't do it, then you cannot file a claim. No, it doesn't mean like that, yeah. Because there are, I think, many jurisprudences also that saying where the demand, the letter of demand is not compulsory. Yeah, it's not obligatory actually. It doesn't mean that even though you don't issue any letter of demand, then the default or breach of contract is not occurring. Yeah. But in the case of this, like I said, when the time is not determined, you are confused, right? When the time is not agreed, the time due is not agreed in the agreement, of course you will be confused. Then when the obligation is due and payable. So on this scenario, you have to send a letter of demand. So that it's clear that based on the letter of demands, this period will be considered as due and payable. Yeah, when it is due and payable, you have to pay. When you don't pay, then you are violating the contract. Okay, so let's see the ICC, the 1238. How to warn a debtor. So if the debtor doesn't fulfill what was demanded, it can be said that the debtor is defaulted. The debtor shall be deemed in default either by an order or other similar deed or pursuant to the obligation itself, where such obligation stipulates that the debtor shall be in default upon failure to deliver within the stipulated time period. Ya. Let's see in the bahasa Indonesia, si berutang adalah lalai apabila ia dengan surat perintah atau dengan sebuah akta sejenis itu telah dinyatakan lalai. Si berutang adalah lalai jika telah dinyatakan lalai. Atau demi perikatannya sendiri ialah jika ini menetapkan bahwa si berutang harus dianggap lalai dengan lewatnya waktu yang ditentukan. Okay, let's look into the elements of it. An order is an official warning by a court bailiff. Ya, si berutang apabila dengan surat perintah. Now, this order we don't see it really in the agreement. Yeah, I mean, when you want to file a claim against the other party in an agreement, there is no order actually. I haven't seen it. I never seen it. Yeah, but this type of order is like unmanning actually, teguran. Yeah, unmanning when you have won the legal claim, for example, and the decision of the courts have become legally final and binding, right? Inkrah, ya, putusan berkekuatan hukum tetap. And the defendant doesn't want to voluntarily do what is decided under the court decisions, so you have to execute the decision, right? You have to mengajukan permohonan eksekusi ke pengadilan, right? You have to file an execution application. So this is that order, yeah. Because when you apply for an execution application, the court will send unmanning order, peringatan, surat perintah, ya. Di sini kan dibilang surat perintah, an order to do what is decided already under the court decisions. That's the relevance of it, yeah. But outside the final and legally binding court decisions, this order is not relevant, yeah. So we don't need really to see this. But the second thing is similar deed, yeah, means a written warning or demand. This similar deed, this one refers to the letter of demand that I mentioned before, yeah. Somasi, yeah, letter of demand. So the 1238, the debtor shall be deemed as default either by an order or other similar deed. So other similar deed, or letter of demand, yeah, or pursuant to the obligation itself, yeah. When the obligation is already clear, you have to pay on the 10th day of the month. You don't pay on the 10th day of the month, then it is clearly default, right? But when it is not clear, you should send a letter of demand. That's why there is a similar deed. Yeah? If a debtor has been warned, but still does not perform his obligation, he is in a state of default or negligent and he can be punished. Now, this is where the consequences of breach of contract coming in actually. Obligation to compensate, cancellation of the agreement, and an assignment of risk. So, in an agreement, and this will be highly relevant with the contract drafting, yeah. If you learn contract drafting, there is a default, yeah, or there are elements that will be considered as default when you do it, yeah, when you violate it, yeah. But there is always, almost always, yeah, not all the time, but almost always a remedial period, which means that you have the opportunity to rectify the default you have made. Artinya kalau kamu melakukan cedera janji, ya, kamu diberikan kesempatan untuk memperbaikinya. Ya, let's say that if you do this, ya, you have 14 days to remedy it, meaning that if you have to pay on certain date, you don't pay, you still have 14 days to repay, right? So it's a given time under the agreement, and that given time can be considered as letter of demand actually, because the letter of demand will also give time for you to do what you have to do. But this is regulated under the agreement. You have time, okay, 14 days to remedy your default. If you don't remedy it after the 14 days has passed, there is an event of default, right? That's why in here that he is in a state of default. Jadi dalam keadaan lalai, dalam keadaan wan prestasi. So in the contract drafting clause, it is considered as an occurrence of event of default. So when you do something wrong, you are not immediately considered as default as long as you remedy your default during the period of the remedial period. As long as you remedy your default in that period, you don't have any consequences. The consequences of default will not happen to you. But when the remedial period has lapsed and you still have not done your part, you are in a state of default. You are, or there is an event of default. Yeah. And because of that, you have to do something. Yeah. You will be punished, right? You'll be punished. And the punishment will be different contract to contract, right? The parties can agree in advance that you have to pay this, you have to pay that, you have to pay delay damages, yeah. Like for contractor, for example, if you promise to finish in 1 year and actually you finished 6 months after, you have to pay the delay per day for that 6 months. Right? So that happens, yeah, that can happen. Or we agree on something amount, some amount that you have to pay if you are defaulting. That can happen also, yeah. Or many other things, yeah. You simply just say that I have the opportunity to cancel, terminate the agreement, for example. So that is the essence of 1238, yeah. My student friends, believe me, yeah, when you become a lawyer and you do the practice litigation or not litigation in Indonesia, you will come by on this 1238 many times, yeah, because this provisions is very essential, yeah, and default, breach of contract are also one of the main repeated occurrences, right, in a business transaction. So it's just a normal thing in this life that there will be a breach of contract. And if there is a breach of contract, you should refer first to the agreement. But if the agreement is not clear, you should refer to the 1238. And this is the fundamental provisions about declaring when the debtor is defaulted. Yeah, that's why you need a letter of demand, unless, of course, the agreement is clearly stating when it is considered as due and payable. Okay, now we are moving forward to the other elements, and this is also not easy. Yeah, until now I'm still quite confused sometimes about how to assess and how to measure it, the cost, expenses, and interest. Yeah. It's not easy in my experience, and also it's not easy for the court to measure it sometimes. Yeah. Well, we have some boundaries, of course, but we have some legal precedents, of course. Yeah, but case by case is different. Yeah. So sometimes, well, I will share my experience on this. Yeah. So, what is the losses? Yeah? What is the compensation of losses? They consist of three things. Yeah, kosten, skaden, and interesten. Yeah. Biaya, rugi, bunga. Yeah, that's the Indonesian term. Yeah. Cost, loss, interest. So, how are they differentiated? Yeah, cost means any expense that has been evidently spent by one party. Example, if a director made an agreement with an actor to have a show, yeah, not a show, to have a show, and this actor does not show up, and hence the show must be cancelled, the cost will be everything. Yeah, promotional cost, advertising cost, rental of chairs. Yeah, there might be a rental of the place, right? So rental cost of the place, and then after you rent the place, maybe you have to bring this, you have to bring that. Yeah, you have to rent this, you have to buy this, you have to buy that. And then suddenly the actor is defaulting, right? This is, of course, if the actor actually defaulted. Yeah, as long as the actor actually defaulted, then of course the producer or the director is entitled to claim these losses, because it's not fair to the director, right? The director already had an agreement with the actor. So you see that the cost is an expense that is really spent. Yeah, really spent by you. Okay, so like you, for example, you go to university, right? You have to pay for Grab or for GoCar or for bus or for anything, right? That's the expense that you have to come to the university, right? That's the expense. That's your expense. So you can see it like that. Yeah. So if you come so every time you come to the university, there are expenses. So similar thing, when you do a show, there are expenses to do the show, right? So when this show is bound by an agreement, the expenses are also bound. So when the show doesn't happen because the other party is defaulting, these expenses I can claim back. Yeah. Now loss, the cost and loss. When we talk about interest, I think maybe it's easier to understand and to differentiate it between interest and cost, or interest and loss. Yeah, but loss and cost are not easy to differentiate. Now let's see subjekti. Yeah, loss means a loss due to damage of the creditor's property, which is evidently caused by the default of the debtor. Example, if a bought cow suffers an infectious disease to other cows that are owned by the buyer so that they are dead because of it. Or the new house recently built collapses due to wrong construction method and damage all house's properties. Okay. Let's see it like this, yeah. So the cost is the actual money you spend, right? But the loss, okay, is not the actual money you spent. Yeah, it's other than that. It's something else. But it also affected me because what you do make a direct consequence of my loss, other than cost, yeah, other than actual expenses. Yeah. So in this case, we see that the new house is collapsing. So when we build a house, of course we spent some money, right? We spent the cost to build the house. Let's say it's 1M, 1 billion, for example. So that's the cost, right? But then suddenly, okay, let's move a bit backward. So that's the cost of building a new house, 1 billion. And then after it is built, of course, I coming in, right? I come in, I have my car parked there. Maybe I built, I put so many furnishings, right? Furnitures, fancy furnitures that I bought, leather style furnitures, right? And branded furnitures, for example, like I buy 20 million, 30 million, 40 million, 50 million, something like that, right? I put all the furnishings in my new house. But because of this collapse of the house, these furnishings are damaged because of it, right? My car is ruined because of this. Well, my car, my furnishings are not related to the cost, right? Because the cost of construction of the house is not the cost to buy the car. It's not the cost to buy the furnishings, right? It's two different things. But because of your default, you're supposed to construct a house properly, right? But the fact that the house is collapsing, causing me losses, right? And the loss is not only about the expenses that I spent for the money to build a new house, but also these things that are cost because the default that you do. The collapsed house damaged my house, my car, my furnishings, my fancy furnishings, right? So now I have cost of construction costs that is gone because the house is gone, right? And I have a claim over loss. What is inside it? Yeah. And you can add also if you are injured, yeah, because you are there, you were injured, and you got hit by the constructions part of the house. You have to go to the doctors because of it, right? You have to pay money for the doctors in order to get well again. These are the things that you can reclaim as loss. Yeah. Because what you do causing me losses, I reclaim it to you. Yeah. Now that's cost and then loss. Now we are going to interest. Yeah. Interest is a loss in the form of loss of profit, which has been expected or calculated by the creditor. Example, in a sale and purchase, when a sold good is already offered with higher price from its purchase price. Well, this one is not easy, yeah? This concept is not easy. But interest can also be seen as bunga aja biasa. Artinya just an interest of the loan, for example. That's the easiest, right? But the interest in the ICC is not only about the interest of the loan, for example, like that, yeah. It's not only about bunga uang gitu ya. It's not about that. It's a loss of profit. This is true. This is very true. And this one is very interesting. So let's say that you are a buyer, right? You are a trader lah. You are a trader. So to trade, to sell some things, you have to buy something, right? Because you are not a manufacturer, you are not a producer, you're just a trader. So when you want to sell something, you have to buy first. Let's say that you find a good supplier, yeah, the good supplier with a good product. The product is cost you 100, for example, right? But you can find so this is the seller, right? The supplier is the seller. The seller sells you the good product 100, for example. The price is 100. But since you are a good trader, yeah, you have many networks, yeah, maybe perhaps you are having apps, yeah, and these apps you have so many followers, right? So you can easily market your products to your followers, and you know that in within your followers, for the same product, they are happy to pay 120. So not 100, but 120. So that is the interest. That is the loss of profit. 120 minus 100. So that's actually the interest. So when the trader, this trader, yeah, cannot buy the product because the supplier is in default, right? For example, that the trader has paid fully the 100, he has paid the 100, but the product has not been delivered. So how much he can claim? He will claim the 100 as the cost because that's the expense, yeah. But there is no element of loss there. Yeah, there is no element of loss. There is just a cost because the cost of the product is 100 by the supplier. But there is also the interest. But this is not as easy as it is, yeah, because you know when you claim an interest, you have to prove it. You have to show it that there is a standby buyer willing to pay 120. So 20 margins, right? You have to prove it. But as long as you prove it, you can claim. So you will claim 120. Even though your cost is only 100, right? Based on this one, cost plus interest. So that is what's happening, yeah. In my previous experience, this is an interesting case actually. Interesting and admitted by the arbitrators, yeah. This is a case of arbitration. This is a simple breach of contract, and it's relevant also with the other items later on by the Professor Subekti. It's very important, I think. I need to share because it's rational, yeah. It's logical. It's not something that is out of the blue, yeah. It's very logical, the principle. Well, I dealt before with a shipping company, and this shipping company was terminated, the contract, by a huge oil and gas company. and the reason of termination is just like some sort of certificate that is actually not really legitimate anymore, yeah. Some sort of certificate that is already presented by the shipping company, so it should not be an issue anymore, yeah. But still, this company terminates the shipping company. Okay, and not only terminating, but also giving a sanction, yeah, blacklist sanction. So what happened? When you, as a shipping company, you were sanctioned, yeah, you were sanctioned, you will suffer that no projects will be given to you by this oil and gas company anymore because you are sanctioned. And that sanction applies for more than 1 year. Yeah, maybe 1 year, maybe more than 1 year. In my case, it was 2 years time. So you can imagine, in 2 years time, this shipping company got sanctioned, blacklisted. They cannot do business. Almost anywhere they cannot do business. But normally, before the blacklist sanction was there, they can do normal business, right? And when they do normal business, they can obtain, let's say, 20 billion per year, maybe more. I don't really remember at the time, yeah. But I think around 20 or 30 billion per annum. Now, we represented the shipping company and we claimed that the termination was wrong. Yeah, the termination was invalid because it violates the agreement. It was not a valid termination. So the termination was unlawful lah, bisa dibilang begitu ya. Was unlawful. So we claim the cost, loss, and the interest, right? And the interesting part is we claim the interest. In that case, we say like this, yeah. You are giving us blacklist sanction, right? And because of it, we cannot do business anymore. For 2 years, we cannot do business anymore. Whether if we don't have the blacklist sanction, we can obtain at least 20-30 billion per annum. Yeah. So what we do, we just do an average per year of what we normally do every year, right? The average income, and we claim it to the company terminating the contract. Yeah, because of you unlawfully terminating my contract and gave me a blacklist sanction, I was very suffering. Yeah, I was very suffering. Yeah, you terminate the contract in the middle, right? I don't get the money for that contract, and then you gave me a blacklisted sanction. I lost my project for another 2 years. So my losses are huge. Yeah. But the interest is the loss of profit. Yeah. Remember that, yeah. Because of the blacklist sanction, I lost my profit for 2 years. That's where it comes into the picture. And we claimed it, and the panel of arbitrators admitted it. Yeah. So they agree to it. They agree to it. Not the 100% of the numbers, yeah. I think they revise it. But the essence is they agree to the claim of interest based on the profit that we lost due to the blacklist sanction. So I think the arbitration case that I experienced before was is a learning material, yeah, because a lot can be learned from that case, yeah. So in here you can see also that the interest can be many things, yeah. In a trade transaction, it is like that. For example, 100 sell 120, so the 20 is your interest, yeah. If you are the lender, of course, the interest will be the agreed interest rate, yeah, maybe 10%, 11%, 12%, etc. But in a shipping case, like what I mentioned before, the interest can be the loss of profit for 2 years because of the blacklist sanction. Okay, let's move on. Yeah, in the case of the prosecution of losses, there are provisions regarding what can be included as a losses. Those provisions are restrictions of what on what can. Okay, this does a debtor who is default is to protect. Yeah, of course we cannot claim anything. Yeah, as I said, we claim these 3 elements. Yeah, and these 3 elements are limited actually. Yeah, the understanding of cost, loss, and interest are limited, right? restricted. You cannot just ask anything, right? Maybe you are stressful, maybe um, what I mentioned in interest loss of profit is 2 years, yeah. But I imagine, if I don't get blacklisted, perhaps I'm not only losing my profit but also losing my uh, opportunity to expand as a shipping company. Nah, that thing cannot be considered as an interest anymore, yeah, because it's too far away. You cannot include indirect consequential damages. So that's what we are going to learn. That's what is the essence of this, yeah. There are restrictions. So the debtor is only obligated to compensate for costs, expenses, and interest that have become evident or must have been foreseen, yeah, must have been expected or must have been foreseen prior to the formation of an agreement, unless if the non-fulfillment of such agreement was caused by deceit. Kecuali kalau ada penipuan. So these are the limits, ya. It has to be evident. Itu harus nyata, ya. Evident itu nyata maksudnya. Tidak bisa dikira-kira. It has to be evident or must have been foreseen. Jadi artinya harus bisa diperkirakan. Sebelum kayak kita tanda tangan kontrak, kalau ini terjadi, maka apa yang saya klaim dalam what I'm going to claim, I can expect it before I sign the contract. Yeah, I can expect it. It's not something that is unpredictable, but it should be predictable. Yeah. Well, it's not easy, right? It's not easy sometimes, but that's the rule of the game. The rule when you file, when you're requesting a compensation. Even if the non-fulfillment of such agreement was caused by the debtor's deceit, ya, meskipun ini penipuan, the compensation of costs, damages, and interest to the extent of losses suffered by the creditor and profits lost by the creditor only comprise of what is the direct consequence of the non-fulfillment of an agreement. So this is the direct consequence. So akibat langsung. Jadi if you are claiming an interest, like my case, shipping company, because you gave me a blacklisted sanction, the direct consequence is I lost my projects. Right? That's direct. Itu jelas-jelas akibat langsung. Because of this, causing this. Ya. Tapi ada juga kan akibat tidak langsung. Like I said earlier, I want to expand my business. I should have expanded my business in the 2 years' time, for example, while the blacklisted sanction was given. Well, maybe you can claim that because of the blacklisted sanction, the direct consequence is you cannot expand. But who knows? Who knows that you will expand anyway? How to prove that you should have expanded if there is no blacklisted sanction? It's not easy, right? The case that I said before, loss of profit of 2 years, we can refer to the last 2 years financial report. And we can show to the judges that these are our normal income if there is no blacklist sanction. It is easier to prove. But when you are talking about expansion, when you are talking about you should have bought another ship, for example, for the business, it's something that it's called indirect consequence. Yeah. It's not a direct consequence. Yeah. Well, sometimes it's not easy, of course. Yeah. How to differentiate direct and indirect? We don't really have the measure, how to measure it, right? But I think it's all also relevant when we talk about unlawful act, right? Kan ada kesalahan, ada kerugian, dan kerugian itu disebabkan karena kesalahan. Jadi, when you suffer losses because the other party is doing an unlawful act, you should suffer losses. Yeah, that's the element of it. Yeah, if you don't suffer losses, you cannot claim for unlawful act. But other than that, in addition to it, even though you and these losses you suffer because due to the fault by this person. So we should prove that the losses is the direct consequence of the fault or the unlawful act. Because of this fault causes these losses to me. Yeah. So it's a sebab akibat, cause and effect. And it happens it happens all the time, right? So we have the thing that we can claim is the direct consequence. The direct consequence of it. We cannot just imagine things, yeah, based on our plannings, for example, based on our imagination. Then we claim it. No, it's not. Yeah, so Indonesian law for breach of contract is limited. So that's why they also protect the debtors. Yeah. So when you are in the position of the defaulting party, you are the defaulting party. You understand that the creditor cannot just claim anything to you until you are broke and make you broke, for example. Yeah. No, it's limited, and different deal, different cost, loss, and interest. Because different deal, of course, different loss, cost, and many times perhaps you don't have any loss of profit. Yeah? Especially if you just want to use it yourself, for example, as a consumer. Maybe you don't have any loss of profit, maybe, yeah, because you want to use it yourself. But as a businessman, perhaps you buy it also to buy it again, or to sell it again, or you buy it and you want to rent it out. Nah, if you can prove that you already have a renter standby, and because of this, the rent falls out, you can file a claim. Yeah, and that is loss of profit. Under both articles, it can be known that the losses are limited. Only a loss that is foreseeable, ya, yang dapat diprediksi, and that is a direct result of the default. Both elements are intertwined. Intertwined, saling terkait, ya. Satu harus bisa diprediksi, satu adalah akibat langsung. Usually, what cannot be expected is also not a direct result. Ya. Apa yang tidak bisa diprediksi, itu juga umumnya bukanlah akibat langsung jadinya. In addition, one of the requirements of what is foreseeable is the amount of the loss. Thus, losses that exceed the foreseeable limit cannot be borne by the debtor unless he has committed deceit, as stipulated under Article 1247. Yeah, well, in my experience in dealing with the breach of contract case, yeah, it's not much actually the losses that you can claim. Yeah, it's not easy to prove it also, yeah, because it's limited. But the least that you can claim, of course, the cost. That's the least. You pay something 100, you file a claim for refund of 100. That's the least that you can claim. But to prove loss and interest are sometimes not that easy. Yeah. You have to build an argument for that, and you have to build your case, yeah, meaning evidences about it. Another limitation is the regulation regarding interest, moratory interest, 1250. Yeah, this is a 1250. In obligations concerning the payment of a sum of money, compensation for costs, damages, and interest due to late performance comprises only of interest that are stipulated by law without prejudice. The compensation for costs and interest obligation needs not be proved. Okay, the compensation for costs and interest is payable only from the day the compensation is requested to the court. Jadi baru bisa dihitung itu when we file it to the court, ya. Remember that. Except in cases where the law stipulates that compensation applies by law. Let's say that the least we can do, if you have a debt, you have an obligation to pay me 100, you only pay me 50, so you are breaching the remaining 50, right? Okay, so if I claim to you, my cost is 50, right? My loss is 50. So you have to repay the 50, right? Because I have given it to you. But this is a sell and purchase. This is not a loan transaction. So I don't agree. We don't have any agreement with the interest rate. So the 1250 says that if you claim for an interest for the money, this is 50, right? You have to refer to the law, and the law says it's 6% per annum. Yeah, this is 6% per annum, but that is not a permanent law, yeah, because the jurisprudences already say that it can be deviated. Yeah, it can be deviated. It can be increased or decreased. No, decreased, but it can be increased, because sometimes it can be claimed like 8% rate, yeah, then 6%. So it is limited to 6%. Yeah, that's the law, and until now it is still applicable. Yeah, so if you claim the 50, you can only request the 6% out of 50 as an interest, and it will only be calculated when you apply for the claim, when you file a claim against through court. That the interest will be calculated until the decision is given. Or you can request for the higher interest rate. Okay, we're still having some slides, so I will move a bit faster now. So the 1266, we have talked about the type of breach of contracts, yeah. We have talked about the consequences of it, yeah. Cost, loss, interest, yeah. But we understand that they are limited also, yeah. They have to be foreseeable and a direct consequence, yeah, not indirectly, not something that is out of the blue, yeah. It has to be justified. It must be able to be justified, yeah. That's the thing. But the second thing that we learn, other than compensation, is also cancellation or termination of agreement. Right? And if we terminate, this is perikatan bersyarat, yeah, conditional obligation under 1266 and 1267. Well, the 1266 says that when the agreement is terminated, it is null and void. Everything must return to what it was before, right? A void condition is deemed to have been included. So this is a conditional obligation, right? Perikatan bersyarat is deemed to have been included. In such agreement, the agreement is not void, but voidance must be requested to the court. So you have to apply it to the court. The request must also be made even though the conditions of voidance concerning the non is included in it. Even though you regulate it specifically, still you have to go to the court. If the conditions of voidance is not included, then the judge, considering the situation upon the defendant's request, has the discretion to fix a time frame to fulfill such obligation. But such time frame may not exceed 1 month. Cancellation of an agreement must be requested to the judge. It is impossible for the agreement to be automatically void when the debtor is default. Yeah, that's why in the practice of contract drafting and in practice in signing a contract, the 1266 is almost all the time waived. So the 1266, yeah, we are back on this. You should read also the 1265, yeah, because it's related. But nobody likes it. Yeah, because nobody wants to have an agreement is considered as null and void, right? Nobody likes it. I want to have the opportunity to terminate just like that without having a must that it must be considered as never happened. That's number one. Number two, I don't want to go to the court. Yeah, I want to be able to have a discretionary authority to just terminate it myself, yeah, without the involvement of the court. That's why it's always waived, yeah, the 1266. But the waiver is not about the um, void conditions, yeah, but it's only on the court's involvement, yeah, that is waived. Yeah. So it would mean that the null and void conditions are applicable, but it doesn't have to be decided by the court. Okay, now the question, why is it regulated? The law views that the debtor's default is a conditional condition, yeah, that is deemed included in an agreement. That's the 1266, right? In every agreement, it is deemed that there is a promise saying that if you debtor defaults, then this agreement will be terminated, yeah. Because the 1266 is related to the 1265, ya. So if you see it, suatu syarat batal adalah syarat yang apabila dipenuhi menghentikan perikatan dan membawa segala sesuatu kembali pada keadaan semula, seolah-olah tidak pernah ada suatu perikatan. But Subekti said, but this view is no longer considered as appropriate. The judge has a discretionary power, the authority to assess the more or less default by the debtor, compared to the consequence of an agreement that may damage the debtor. When the judge considers such default is too small, meaningless, where that cancellation will bring huge losses to the debtor, then the request to cancel that agreement will be declined by the judge. For example, when the tailor has accepted such work for 1 battalion of soldiers and such default is only related to the numbers of buttons in the shirts, then the judge may decline or should decline such claim of cancellation agreement. This will also be considered as violation of good faith principle. Nah, itikat baik, ya, asas itikat baik itu dalam pelaksanaan perjanjian. It is regulated under 1338 paragraph 3, right? The null and void principle is a principle when it is appropriate to be performed. Because how do you return? When you enter into sell and purchase transaction, you can return the product, you can return the money, right? But when you have a lease agreement, for example, rental agreement of something, how do you return the satisfaction of occupying the space already, right? Because you have occupied the space or you have used the goods, the products that you have rented, how you return. So that's why the Professor Subekti said that this is a principle when it is appropriate to be performed, yeah. So it is not like an absolute principle. And what is important is on the third point in here, yeah. When the judge considers such default is too small, yeah. So the Professor Subekti discusses this matter because to him, if the agreement is considered as null and void just like that, it will be unfair to the other party that is defaulting. For example, this tailor, right? This tailor already finished almost everything, but the buttons are not complete as required by the agreement, right? And then it is considered as null and void. So it doesn't make any sense, right? Because the tailor seems to be treated unfairly. Because let's say that by this action, he has completed maybe 95%, 97% of his performance. Why? Because due to the 2-3%, everything is collapsing. It doesn't make any sense, right? It doesn't make any sense, especially when this is only a minor thing. It doesn't make any sense. The law doesn't supposed to be like that, right? I mean, the law for everything that is regulated under the law in writing, it doesn't supposed to be regulating something that is illogical or irrational, right? Or unfairly. So it's supposed to regulate with fairness, yeah, that is justifiable, that is logical, rational, and can be justified. So this is actually a principle of balancing, asas keseimbangan. This is actually that thing. And in my previous case on the shipping company, I said that they have a certificate, yeah, but what the certificate that they have was considered as not legitimate by the oil and gas company. So oil and gas company terminates the agreement, right? But actually, it was a legitimate certificate, yeah. So that make the arbitrators at the time consider that the action by the oil and gas company is violating the balance principle, yeah, because the arbitrators consider that the reasons to terminate is small reasons, yeah, like this small meaningless gitu. Minor gitu lah, minor. It's a minor reason, it's small, minor, meaningless reasons that you use as your ground for termination, right? So this is very important, yeah. So you all have to remember, not everything that you regulate in the agreement you can just proceed with it without any consequences, yeah. In this case, the oil and gas company just proceeds with it, right? Just to terminate, because they consider that this was not legitimate. I have the full authority to decide whether this is legitimate or not. Yeah, they consider, their mindset is like that. But the law is different. The law is not directed by the mindset of the oil and gas company. The law is the law. You can interpret this law like that, but the law is something different. So that's why your mindset, you have to be very careful as legal practitioners in the future. We have to see the law as objectively as possible, not subjectively, because if you involve too much subjectivity, then you lost the value of the law. Yeah, this is the small meaningless. Well, this is the value of the law, right? It might not be written in the law. It might not be in writing, right? But this is actually the value, the fairness value, the balance value, the rationality value, yeah, where the law should be logical, should be rational, should treat the other party fairly, yeah. When the other party can just terminate with minor reasons, meaningless reasons, that doesn't seem logical. That doesn't seem fair, of course, right? So that's why we have to understand also that it does not everything that we regulate will be considered as binding. Yeah, we have to remember that. The transfer of risk as a third section. What is meant by risk is the obligation to carry out losses if there is an event outside the fault of one of the parties, which befalls good that is an object of the agreement. The risk assignment can be described in Article 1460. Di peralihan risiko ya maksudnya. If the asset sold consists of determined goods, it falls under the liability of the buyer from the time of the purchase, notwithstanding that delivery has not yet taken place and the seller is entitled. On this matter, we will talk about it specifically later on, maybe 2-3 classes from now. Yeah, this is an interesting part also, but it doesn't make any. It's quite confusing, right? The 1460. I think Professor Subekti also raises this issue. If the asset sold consists of determined goods, it falls under the liability of the buyer from the time of purchase, notwithstanding the delivery has not yet taken place and the seller is entitled to demand the payment. So the risk is borne by the buyer. Yeah, even though the product has not come to the buyer. Well, it's quite confusing. I think, well, that's why we have to talk this matter separately. Yeah, because it's interesting. Now the pay the court fees, I told you already about this, yeah, so we don't need to talk about this anymore. And now the 1266 is also, there is a 1267. So the 1266 is a principle, it's a null and void principle, but as Professor Subekti said, it is not always be performed, right? And in the practice, it is almost always waived by the parties. So under the legal practitioners world, yeah, we consider that kind of 1266 is no longer applicable. So it's not null and void, and we don't need to go to the court to terminate an agreement. That's important, right? Because we want to have an authority to just terminate without court's involvement. Now the 1267 is different. The party against whom the obligation is not fulfilled may choose. Yeah, so this is talking about the party who is not defaulting. Yeah. So this is talking about the creditor to compel the counterparty to fulfill the agreement where such fulfillment is still possible. Yeah, when it is still possible, or demand the cancellation of such agreement with compensation of cost, damages, and interest. Yeah. So he may choose either to ask for performance, right, or just to cancel with compensation. So if you demand the performance, you still request the cost, damages, and interest, right? You are allowed to do it. If you demand to cancel, you are also allowed to include cost, damages, and interest. So this is optional. So 1267 is actually good. Yeah, it's actually good. You have the options as creditor to do what you want the debtors to. And most of the time, of course, it's always the second one. Yeah, you want to cancel and you ask for compensations. That's normal one. Yeah, but recently I have a case that I choose the first one. I just want you to do your performance, but I claim for cost, damages, and interest. Yeah, so it's very rare case. It's not happening all the time, but it happens. Yeah. Because these are optional. This is our option as the creditor to choose which path we want to take. So according to Article 1267, the creditor can sue the default debtor a fulfillment for the agreement. It can also determine the fulfillment. Okay. So in overall, in conclusion, yeah, creditors can choose between the following demands: fulfillment of the agreement. You just have to fulfill it. Fulfillment of the agreement with compensation. And you have to do it with the money. Or just compensation. Okay? I don't want to talk about anything of fulfillment anymore. Just pay me. Okay? Or cancellation. Maybe I just don't like you. Yeah. Maybe there is no ground for cost, losses, and interest. Maybe. I don't know. Maybe the performance of the party hasn't happened yet. I just changed my mind. I just want to cancel. Or cancel, but with compensation. consequences.